Welcome to the Evershed Sutherland Inquiries and Inquests podcast. I'm Catherine Henney, a legal director in the Inquiries and Health and Safety team, and today I am joined by Kate Grange KC, barrister from 39 Essex Chambers, and Nick Griffin KC, barrister from QEB Hollis Whiteman. This episode is titled, How do you approach a public inquiry when there are criminal proceedings running alongside? I had the pleasure of speaking to Kate and Nick and asked them to reflect on their significant public inquiry experience, including from the Grenfell Tower inquiry, where Kate acted as lead counsel for the inquiry and Nick for two core participants. We discuss what tools are available to inquiry chairs to manage the risks where there are separate criminal proceedings, including how to ensure engagement of inquiry witnesses and core participants, and when undertakings or anonymity orders may be appropriate. We also discuss the powers of suspension and how a balance must be maintained to ensure that proceedings on both sides can progress as expediently as possible. In this podcast, we use the terms victims, survivors and families for ease of reference, and that's not to ignore the preference of many, including those in Grenfell, to be referred to as bereaved or relatives instead. The views expressed in this podcast are also personal to the speakers. Thank you for listening. So Nick, I'm going to come to you first, if that's okay, and ask you what, in your view, are the primary considerations when you are dealing with an inquiry where there are criminal proceedings running alongside?
I think the first point to make is the more general point, which is I can't think of a public inquiry I've been involved in which hasn't had a variety of different proceedings going on in parallel, or at least the possibility of them. So not just a criminal investigation, but civil proceedings, domestic and international, the possibility of select committee interest, ombudsman interest, and obviously also where police or other professions are involved, the possibility of regulatory and disciplinary action as well. So I think the first point is you need to be keeping an eye on a whole range of potential proceedings that are going on and that have the potential to derail an inquiry. But just focusing on criminal proceedings, I think what we're dealing with here is either an actual investigation that actually has already started, or at least a real possibility that there will be police interest in individuals and organisations who also have to engage with the public inquiry over substantially similar matters. And looking at it from two different perspectives, I think there are dangers that arise in that kind of situation. Looking at it first from the point of view of the police and the prosecuting authority like the CPS, and also from the point of view of the inquiry, what the main focus there will be is the extent to which the inquiry may prejudice the criminal investigation and proceedings. Mm-hmm. And you could see how that would happen because the rules of admissibility in a public inquiry are very different and much more lax compared to those in criminal proceedings. And so if you have a witness, for example, who's called to give evidence at a public inquiry, the scope of what they might be expected to cover will be wide. It will be made public, and that might be shortly before a criminal trial where at least some of that might be inadmissible. Mm-hmm. And you could see how that would create potential for prejudice. There are ways of controlling or mitigating that risk. It's not science and is not guaranteed to work, but one of the great tools of a public inquiry, whether it's statutory or not statutory, is the rules of procedure are very flexible. Mm-hmm. and are largely down to what the chair says they are. And those procedures can be adapted to try and minimise the chance of prejudicial material getting out into the public. There are also rules in statutory inquiries that allow a chair and indeed a minister to restrict publication of information. So that might be another way of restricting or in dealing with potential for prejudice. And as I say, there is a wide discretion generally, including in terms of restricting or at least controlling the types of questions that are asked. But as I say, that none of that is a real science, and there are always risks involved. The other perspective to look at things from is from the inquiry witness, and someone particularly who may go on to become a criminal suspect, or who knows they're a criminal suspect. That might be an individual or an organisation, and they might be called to give evidence at an inquiry covering the same type of thing they would be interviewed about by the police. They'll come under a lot of pressure from an inquiry to give information, particularly if the area that they'd be asked about by the police is very similar to the area that the inquiry is interested in. There is a privilege against self-incrimination in statutory public inquiries, which would mean that the person could not be forced to incriminate themselves. The difficulty there is that this is all happening in public, and there is a real reputational risk to an individual who invokes the privilege. And if they do invoke the privilege, that may deny the inquiry of really important information. And I think one of the points we might come on to deal with is the possibility of undertakings from the Attorney General, which would become relevant there. But that's looking at it from two different perspectives.
Yeah, that's really helpful, thank you. And I think one of the things that strikes me listening to you talk there is one of the ultimate risks, I suppose, is engagement, and how an inquiry secures the engagement of individuals or organisations when they are facing such a complex sort of myriad of issues there with criminal proceedings are running alongside. So just thinking about perhaps then what tools are available to inquiry chairs. Kate, you must have faced a number of these questions in Grenfell Tower inquiry. I just wondered how the inquiry sought to manage those risks from your experience.
Yes, thank you. I mean, it was clear from the outset of the Grenfell inquiry that it was going to be a very complex and multifaceted investigation involving lots of different players and lots of different aspects to the investigation. And it was also clear right from day one that the police investigation was going to be running in parallel with the inquiry investigation. And it's fair to say that both sides were quite nervous about that. How are we going to do this? How are we going to make this work? Mm-hmm. And the first thing really we had to do was build trust with each other, that we weren't going to step on each other's toes and we could work together, and also trust with the Grenfell victims, many of whom were understandably concerned that we might prejudice the criminal investigation during our work. So essentially the way we dealt with it was to have extremely close liaison, really for the whole of the 7 years that the inquiry ran. Now, that started with a memorandum of understanding, a written document that was published, which explained how we were going to share information and documents, and a process for that, with each side getting warning of potential disclosures so they could raise concerns about what happened. And then really it was quite practical, regular meetings between the Met Police and our teams to explain where we'd got to, where they'd got to, where we were going next. So step by step, stage by stage, we communicated, and a process for working alongside one another evolved so that we weren't treading on each other's toes. And at the beginning, just to give one practical example, the Met had control over the building. It was a scene of crime. And we wanted to agree a process by which our experts that we'd appointed could get access to the tower and undertake investigations and inspections, all of which proved to be really valuable in terms of uncovering, for example, all the combustible materials in the outside wall, but in a way which didn't prejudice the evidence gathering by the police. So we had to agree quite clear protocols about that. And looking back, I actually think now you can make out a case for why each side benefited from having the involvement of the other in parallel. And that's certainly not where we thought we'd be at the beginning. And just a couple of examples, we very quickly appointed experts to help us. And we had some of the best fire engineers in the world assisting us. And they quite quickly alighted on the fact that there was some conduct of the manufacturers that didn't look good. And in fact, as we now know, in the inquiry report, we found that there was systematic dishonesty in the fire testing practices over a number of years of these manufacturers. And if the inquiry effectively worked that out with the help of our fantastic experts, and we were sharing information in hearings, sharing it with the police, so they understood quite early that there was a whole hinterland of potentially fraudulent testing activity that they might need to look into. How did we benefit? Well, Arconic manufactured the outer panels which clad the tower. They're a French. It was a French company, although US parent, and these panels that they manufactured, inside was this core of polyethylene that produces more energy when it burns than petrol. Now, because Arconic was based in France, we hit a legal problem because the witnesses said, well, there's a French blocking statute, we are not going to cooperate with your inquiry, we're not going to give witness statements, we're not going to come and give oral evidence. And it's all in the inquiry report. What happened was we worked with the police and they obtained 2 European investigation warrants, which enabled them to go to France, obtain documents and witness statements. And we fed questions into that process. So, we gave a list of the areas that we were interested in, and so they could be swept up in the process. And then when that information had been gathered, those statements and documents were handed to us, which meant that we did have a cadre of evidence from Arconic, which was actually pretty critical in the inquiry. So those are just some of the examples where, looking back, I think we both benefited from having the other one alongside. I guess the real test will be to see whether, and if so, how successful any criminal prosecutions actually are in due course. But I don't think that we've done anything to hinder those investigations. I hope, on the contrary, we've actually assisted. And I also don't think we've delayed anything either. I mean, when I step back and look at it, we had a million documents, of which about 300,000 were relevant. The police have explained they've got 152 million relevant documents. Yeah. So that investigation was always going to take a long time, have to be very involved. And I'd like to think that what we did was shine a light on failings, including government failings over the 30 years before the disaster, which really, showed that getting the inquiry going was worthwhile, even though the police investigation was ongoing.
Yeah, and I think that delay point that you touch on there is one, understandably, the victims have also picked up on. And I know that there was some press in, I think it was May 2024, when the Metropolitan Police came out and said there wouldn't be any prosecutions probably till 2026 or 2027,
yeah, that's right. 2026, even. I think.
And when you look at it in the context of that volume of documents, that's perhaps understandable. Although from a victim point of view, you can understand they say, well, this is justice delayed, given how long ago the fire was now. And I think, Nick, in terms of that sort of justice delayed point, we've had conversations previously, and you've mentioned that there was a particular report that focused on justice for victims.
Yes, a couple of years ago, Justice, the campaigning group, ran a When Things Go Wrong working group, which led to a report. And the working group was considering the inefficiency of legal processes after a catastrophic event or systemic failure resulting in death or injury, with insufficient concern for the needs of those affected by disasters. So it was looking at the multiplicity of different types of proceedings that spring up, the fact that they don't always liaise with each other, and that in itself can cause problems. And we're wondering whether there was a better way forward that properly took into account those most affected by what had occurred. And one of the things they looked at was whether criminal proceedings should precede inquests or inquiries or that type of process. And the decision there, the conclusion was a presumption, not a rule, that the criminal proceedings should precede the public inquiry. But I think that the real point is that it will be case specific. And I don't know whether or not Kate agrees, but my feel is that, generally speaking, inquiries are more prepared now to plough on, to put in place the kind of MOU or whatever it is with the police, but not to delay until the criminal process is concluded, which may take a number of years.
Yeah. And it's interesting that, isn't it, when you look at that alongside inquests, where ordinarily the criminal proceedings will go first and the inquest will be put on hold until that's happened. And ordinarily, and often actually, the discretion of the coroner might be that they don't hold an inquest before. For example, if you're getting on a murder conviction perhaps, and then therefore they decide that there's no need to hold one. And also, interestingly, I think that that's often to ensure that any conclusion of the inquest is not at odds with the findings of the criminal case. That doesn't seem to be the case, as you say, with inquiries. They're more content to plough on, even though they do have a power to suspend. And I'm interested in that particular point, and I don't know if you're both aware of the Supreme Court decision known as JR 222. That was in relation to the Mucklemore Abbey Hospital inquiry. So the Mucklemore Abbey Hospital inquiry is a statutory inquiry being held in Northern Ireland and is investigating allegations of historic abuse of patients at the hospital between 1999 and 2021. JR 222 is the pseudonym given to one of the hospital employees who's been charged with criminal offences connected with that abuse. And the JR 222 case itself arises from that individual's request that the inquiry should be suspended under Section 13 of the Inquiries Act until the criminal case against her was concluded. Now, Section 13 allows for an inquiry to be suspended, and I paraphrase, for such period as appears to the Minister to be necessary to allow for the determination of any civil or criminal proceedings. The Minister declined JR 222's request for suspension on the basis that he did not consider it necessary to suspend the inquiry to allow for the determination of the criminal proceedings against her. So JR 222 brought judicial review proceedings against that decision by the Minister and argued that the Minister incorrectly applied the concept of necessity to the entirety of his discretion under Section 13, and actually that instead the word necessary only related to the period of the suspension and not the decision whether or not it was necessary to suspend at all. What happened next was it went to both the High Court and the Court of Appeal, and both of whom dismissed JR 222's challenge, holding that the Minister had applied the correct test. Not defeated, JR 222 then appealed to the Supreme Court, who also unanimously dismissed the appeal and held that necessity under Section 13 applies to both the purposes for suspension and to the period of suspension. Now, that leaves us with a clear message, I think, from the courts that in terms of exercising the power to suspend an inquiry, the threshold is likely to be quite a high one to reach, and not simply because it should allow criminal proceedings to go first. Just reflecting on that, how do you feel about sort of that decision and your experiences of inquiries? Is that right? Because if I just listen back to what you were saying, perhaps, Kate, there, and the wealth of evidence that's come out of Grenfell and the inquiry, one could perhaps turn that on its head and say, well, are you able to have a fair criminal trial at the conclusion of all of that? Because so much of then those arguments have already been rehearsed in public, that is anybody who's then on trial able to find a jury who is able to run a fair trial for those individuals? I just throw that out there for discussion.
I think the first point is that it will be case specific.
Yeah.
But there are, as I was saying earlier, a number of things that the inquiry can do to try and limit or mitigate the risk. And as I said, we've talked about those. Ultimately, the test, what you're looking at probably would be an argument of abuse of process on behalf of a criminal defendant, potentially because of adverse pretrial publicity, i.e. inadmissible information that's out there that the jury might have access to. The test for a successful abuse application in that kind of scenario is quite a tough one.
Yeah, it's a high threshold.
It's
with
a
any
high
abuse.
threshold.
Yeah.
So that's another matter to take into account. So I think the answer is that a criminal court ultimately would take quite a lot of persuading, even if there is a fair amount of information out there arising from a public inquiry, before it would agree that a trial should be stopped, even before it started.
I agree with that. But I think you said at the beginning it's a matter of context. I think where you've had the actions of one single individual put under the spotlight in an inquiry with a lot of headlines, I think that's where you might start to get the bones of a case together. I mean, with Grenfell, there's so many different parties that have ended up being, quotes, culpable in the inquiry's view. that I think it might be quite hard to get close to that test, is my feeling. But I think if you'd had a case like, I suppose, the Lucy Letby situation, where you've had a focus on one single individual, that could get quite difficult. And I can see why the criminal trial would go first.
And we can and also we can see now what's coming out of that is that there's a lot of challenges to certain offences and convictions, and also people raising challenges as to whether those were properly found convictions. So that rumbles on whilst the inquiry rumbles on. But I think what's interesting is when you also look at the JR 222 decision and what the Supreme Court said, they made a point of saying, the whole statutory purpose of an inquiry is to address public concerns. And so if you were to suspend the public inquiry for a period in order to await the outcome of a criminal proceedings, then that would be contrary to its statutory purpose. So there seems to be a real sort of tension there, almost as a bit, you're trying to address public concern through two different justice means. One is a public inquiry, one is a criminal trial or process. So just moving away from that and moving towards some of the other tools, we talked about not just suspension, and looking at what you were saying, Nick, about the when you've got a lot of evidence out there in the public domain. There are other tools such as restriction orders that can be used in inquiries, ways in which questions and evidence can be managed by the chair, redaction of material. But one of the things we started at the top of the conversation that you raised, Nick, was about Attorney General's undertakings. And I'm just wondering if you could give us a little bit more of your experience on when those might be appropriate and useful, because my interpretation is also that perhaps they're often misunderstood as to what they're able to do, and perhaps the public perception of what they are there to do. So, Kate, I just wondered if you could perhaps talk about your experience of using those, and then get Nick's reflections too.
I think it's very interesting looking at what's happened over the years with this. Historically, lots of different inquiries have sought undertakings from the attorney, essentially to say that the evidence given in the public inquiry will not be used in any future criminal proceedings against that person. The undertakings have varied. Different attorney generals have given different undertakings. They normally won't ever include anything to do with perjury, but some undertakings have been broader. Some preclude the use not only of witness statements and oral evidence, but also written statements made preparatory to giving evidence, or documents produced by that person to the inquiry. That happened in the Bloody Sunday inquiry. Mm-hmm. And I think one interesting trend that you can see, I think, over a number of years, is that a lot of inquiries historically would have applied for these quite early on, kind of preempting the idea that they're going to need these undertakings. Otherwise, people will stay silent, they won't give evidence, and there won't be that corpus of evidence available to the inquiry, all because of this privilege against self-incrimination. And so we saw those being obtained in the Stephen Lawrence inquiry, Bloody Sunday, Ladbroke Grove, Baha Musa. Mm-hmm. The approach the chairman took in the Grenfell inquiry was to wait and see. And I think we can see a similar approach in the Post Office inquiry. In Grenfell, the chairman's position was that someone would have to make an application and explain why they wanted the undertakings and why he should seek them from the Attorney General. And no one made that application for really quite some time. And in fact, we got all of the witness statements, all the key ones, in for phase 2 of our investigations without anyone raising the need for them. So those witness statements can now be used in criminal proceedings. Mm-hmm. And then it was just before we started taking oral evidence in the module that was looking at the building professionals who are responsible for the cladding system at Grenfell Tower, so looking at the architect, the fire engineer, the builder. Looking at those professionals, it was just before that where we were really going to look into the detail of who was responsible for the dangerous condition of the building, that we got an application from a group who came forward and said, we want these undertakings given our right to the privilege against self-incrimination. And the chair was persuaded, and we were able to quickly get those from the Attorney General. But I think you can see a similar wait-and-see kind of approach with the Post Office inquiry. And so when Williams in that inquiry, Gareth Jenkins was a Fujitsu employee who's had quite a lot of focus on him in that inquiry. And Sir Wyn Williams gave a decision in which he said, I'm going to wait and see. I'm not giving him these undertakings or asking for these undertakings on his behalf because I've got lots of other evidence, both documentary evidence, oral evidence, that I can rely on already. And although he said he won't answer certain questions, let's wait and see because I might not have a void that I need to fill. Mm-hmm. And so, again, you're seeing this, I'm not going to ask for them preemptively, I'm going to wait, see what the need is, and then ask. So I think there's a bit of a trend there in the chairs not jumping too early for obtaining these important guarantees.
And can I ask there, before I just come to Nick, to you, Nick, for your reflections, what response did you get from victims and survivor families to that approach? I'm just interested in the arguments that played out.
Yeah, I think at the time it all happened quite quickly, and there was a bit of a misunderstanding in some quarters that, or certainly in the press, that this was some kind of immunity that was being sought and granted. And we did have to explain what are Attorney General's undertakings, what do they mean? They don't mean that people can't be prosecuted. It just means this particular piece of evidence can't be used in that. So yes, I think in terms of the public reaction, it was interesting to see how that was interpreted. But I'd like to think that the families with the lawyers that they had would have come to understand what was actually going on. And I personally think had we applied for them at any stage, we would have had a similar kind of reaction because there's such nervousness around Grenfell and whether there's going to be prosecutions and the basis for those.
Yeah, okay, understandable. Nick, can I get your reflections, having been involved also in Grenfell?
Yes, I'm happy to give my reflections, although they're not Grenfell specific. The undertakings do present a response for an inquiry where it's in danger of losing key evidence. And as we were saying before, that might be where there is someone who's of interest to the police who could rely on the privilege against self-incrimination not to share with the inquiry key information and therefore decides to rely on that privilege. The undertaking unlocks that. And as Kate has said, it comes in a variety of different forms, including not from the Attorney General. Sometimes you get professions that agree not to investigate or bring proceedings for disciplinary or regulatory matters, that type of thing. So it can be quite wide. And then they can be quite specific as well. They might just be about allowing someone to provide information, for example. So there's a whole range of them. But I think there is a potentially important role for an undertaking if an Attorney General is prepared to give it. I think there's also an argument for considering whether undertakings should be sought at an early stage. So, for example, not waiting. And what I think an inquiry will want to do is from the start to remove barriers to obtaining key information. And you will want people to come forward and provide as much information about the terms of reference that they can. If they're concerned that they may become criminal defendants and don't want to do anything that might increase the chances of interest or indeed conviction, the inquiry might lose that. So I wouldn't necessarily advocate waiting to see whether the issue needs to be addressed. There is, as you said, a lot of misunderstanding about what an undertaking is, and it's not a sort of get out of jail free card. It's not immunity. And I think if an inquiry is going to seek undertakings, it should be clear about what it's doing and what the ambit of those undertakings would be if granted. I think that in Grenfell there was some consternation because the issue was brought up late, and that could have been, well, that might have been avoided had it been addressed at an earlier stage. But I take on board what Kate has said, and I do think there is something to be said for addressing the need for undertakings right at the start of an inquiry, and that would probably be my preference.
But perhaps also it's just some kind of a statement from the chair or an explanation of exactly to deal with that, exactly the public perception point, what they are there to do and what they're there not to do, and that will be kept under under review during the inquiry, perhaps, because I do think there's an element of trying to bring the public along with you, and certainly bring the victims and survivors' families along with you, so that they really understand the process, particularly because sometimes it gets swept up in the media and trying to understand exactly what's going on. And interestingly, the other thing I was just reflecting on is when, instead of going down the undertaking route, you could go down the anonymity route. And obviously, again, that presumably is going to be fact specific, because some organisations and individuals will be clearly identified or identifiable depending on what their role was. But there must be cases in which we could say, okay, well, we're not going to go down an undertaking route, we'll go down an anonymity route, and that might, although that doesn't prevent that person from being prosecuted or the criminal, but it might certainly help with the engagement point, that they will come forward and they'll speak if they're speaking anonymously. I just wonder whether you had any experience on the anonymity or any reflections on that.
Well, I think an inquiry chair is going to want to use all the appropriate tools that they can to get the information that they need. I personally can foresee certain difficulties with going down the anonymity route in this kind of situation, but I suppose, again, it's fact specific, and it may work in certain circumstances.
Yeah, I agree with that.
Just one last question I have is just talking through all these tools available to inquiry chairs. Is there a difference if we're talking about a statutory inquiry, if you're a chair of a statutory inquiry, versus a non-statutory inquiry, and the tools that are available to a non-stat chair?
Well, I think there are fundamental differences. Partly that arises from the expectation of what will be in public. In a statutory public inquiry, there is a very much presumption that it will all happen in open. Less so with a non-statutory inquiry, which can happen behind closed doors partly, or quite a lot actually. But I think it probably ultimately comes down to the fact that a statutory inquiry has powers to compel evidence, and they could require a potential criminal defendant to come and give evidence unless that person relied on the privilege against self-incrimination. Whereas a non-statutory inquiry doesn't have those powers. And so someone who was worried about a criminal investigation could just refuse to cooperate.
Yeah. And I think that's why we've seen a lot of non-statutory inquiries converted to statutory inquiries, because that's exactly what's happened. They have refused to cooperate, and in order to get that evidence, you've then got to have those teeth, and with that comes the bells and whistles that you might need in terms of things like Attorney General's undertakings.
And it's quite timely, actually, because we've seen a lot of the press in the last couple of weeks over the grooming gangs and ICSA public inquiry, and calling for another public inquiry just for that reason, so that they can have the powers to be able to compel, whereas others say if it's a non-statutory or independent inquiry, it doesn't have those powers. That's obviously still playing out, and we'll see where that goes. But I'm really grateful for all of your reflections and all of your time, and thank you very much.
Thank you.
Thank you.